Chapter 42. The Justice of the Peace. In reading in the history of American law, I realized that, however able the histories were in recounting and analyzing major currents in court decisions, they overlooked the most common court and the most active judge of all. Prior to 1940, the major activity in the American legal system was in the hands of the local Justice of the Peace. This court still exists, but in many states it has been abolished. The courts of the Justices of the Peace are of ancient origin. In England, the Justice of the Peace had as his duty to, quote, keep the peace, end quote, in the local jurisdiction for which he was appointed. He was someone from the area, at one time from the landed gentry, and the cases he tried were not of great financial consequences, and yet were important in maintaining law and order within the community. The basic duty of the Justice of the Peace was, and is, the enforcement of all laws, ordinances and statutes to maintain law and order and to enforce peace and harmony among the people. English law made the local mayor ex officio a justice during this term of office, gave him precedence over all justices in the borough, and he could take the chair at any meeting, although there were and are limitations on the scope of his precedence. In the United States, the JP, or Justice of the Peace, is normally elected. His is the lowest of all the state courts, and normally he is not a lawyer. There are limits on the value of civil suits, and in criminal cases, misdemeanors, the guilty party is not jailed unless he refused to pay the fine. At one time, the Justice of the Peace Court was, in the United States, the busiest of all courts. It once had the key role in American legal life, and some justices of the peace, whether for good or ill, were the law in their areas in the early history of the West. The Justice of the Peace, not being a trained lawyer, might have few law books or none at all. He relied on the Bible, local standards, and, quote, common sense, end quote. His decisions had to meet the demands of the local community for law and order. The decisions of the Justice of the Peace had, normally, great receptivity in the local community, and the courts functioned for generations with success. As legal education of an academic character increased, the standing of the Justice of the Peace decreased in the eyes of legislatures, who were increasingly lawyers. The result was the decline and, in some states, the elimination of the Justice of the Peace. Since writing Institutes of Biblical Law, I have occasionally heard from Justices of the Peace thanking me for providing them with a convenient manual on the subject. The work is also used by them in their decisions. What is important in all this is that we once had quite generally a means of handling most cases on the local level. Given the more Christian character and standards of earlier America, serious crimes like murder were less common, and most cases were within the jurisdiction of the Justice of the Peace. Within my own lifetime, most superior court judges were elderly men. Many were partners in major law firms which ran for office an older member as a public service. It was a position which did not pay well, but the work then was light. The judge would step aside if his firm were involved in a case. As a partner in the firm, he sometimes still had an income. Since then, judgeships have become political rewards and state superior courts are more crowded. The power and jurisdiction of federal courts have also grown. Instead of a neighbour enforcing basic law, now the law system is remote to the people and to their faith. It has been federalised in the name of democracy, which has come to be another name for the centralisation of powers. A return to the Justice of the Peace will not solve our problems, however. The growing decay of character has created the need for courts to try cases beyond the scope of the JP and his court. Murder, rape, arson, and all the multitude of current offences require more involved trials in courts of record. The solution must begin with a return to the most basic form of localism, a stress on the faith and character of the people. Because of antinomianism, the erosion of the people's morality has been great, and no system of civil government can restore it. There must be a return to the centrality of faith and morality. Nothing else will suffice. The justice of the peace is related to the biblical and English and American hundreds courts, to the emphasis on rule in God's way and with God's law.